The Sethmar Story. Thanks for joining us again. Our conversation this week is with attorney Kristen Johnson around California's AB 5 law.
One thing that, before we really dive into this, is just a legal disclaimer that any of the information that is discussed or provided in this podcast is not intended to be or constitute legal advice. And to the extent anyone listening has any questions about AB 5 or how it may affect their particular situation, they should contact their own attorney for specific legal advice.
Yes, and I will echo that as well. I represent many wonderful transportation entities around the nation, but this podcast is for your information only. And if you have specific questions about your situation, you can feel free to call me and we can set up a call to talk about it, but this is not legal advice.
Okay, well, welcome to episode 2 of the Sethmar Story. I'm Adam Gasper, General Counsel here at Sethmar Transportation. And today, my guest is Kristen Johnson of the law firm of Taylor Johnson. And Kristen, with that, go ahead and introduce yourself, please.
Thank you. I appreciate it, Adam. It's fun to be on your show. I am Kristen Johnson. I'm an attorney. I've been practicing for about 15 years. My practice is primarily in transportation and logistics. My law firm is specialized in transportation logistics, meaning we serve motor carriers, brokers, freight forwarders, some shippers, and some warehousemen as well as our primary client base. And we practice based out of Florida, but we are nationwide because obviously the practice of transportation is not limited to one state. I myself am barred to practice in Florida, California, and Washington, D.C. And we handle interstate and federal issues all across the nation.
Well, thank you for coming on today. And I specifically asked you to come to tell us a little bit about Assembly Bill 5 out in California and how that may affect the transportation and logistics industry going forward. So if you wouldn't mind just kind of giving us a little overview right off the bat of what AB 5 is and sort of how it is going to affect certain segments of the transportation and logistics industry directly.
Well, most importantly, AB 5 is now law and it has been codified in California and is part of the law there. And it is a very broad sweeping law that codifies the test for determining whether an independent contractor or a person hired by someone, by a hiring entity, is misclassified and should have been hired as an employee and not an independent contractor. It's also important because it applies to all sectors of law in California and is the predominant test that will be used by agencies as well as courts in determining whether someone has been properly classified as an employee or an independent contractor. What it did is it basically codified a test that had already been in existence in California, but had not been consistently applied in all situations relating to misclassification. It codified what is known as the ABC test, which is a 3-part test. And the way that it is written in California is renowned, I suppose, for its difficulty in meeting the test, meaning it is difficult for someone to prove that they have hired an independent contractor as opposed to having hired an employee. And so that's why California, I think, has risen in its notoriety over this test and over AB 5. A little bit of background for you. AB 5 came about initially as a law aimed at the gig worker economy, at Uber, DoorDash, Lyft, all of those guys, because there was a general perceived complaint that drivers who were all at the time considered independent contractors were misclassified and they should have been employees. It has the effect, though, of impacting the larger industry, including the trucking industry, which, as you know, uses a lot of independent contractors in filling capacity gaps where you need to have drivers, or you want to have drivers that are part of your fleet, but are not necessarily employees. And that comes from the drivers themselves sometimes wanting that, or the needs of the company that is hiring the independent contractor. So AB 5 has a direct impact on the trucking industry because it literally regulates whether an owner-operator or a driver of a vehicle can be classified as an independent contractor with a trucking company that is hiring them.
And I understand basically that in California now, an owner-operator cannot be exclusively leased under AB5 and still treated as an independent contractor?
That is the general tenement. There are ways that folks are trying to work around that, but an exclusively leased owner-operator is problematic because if they're being hired by a motor carrier, if they're leasing onto that motor carrier, they would fail what's called the B prong of the test. The B prong of the test requires that the entity hiring the independent contractor is in a distinct line of business from that independent contractor. And it's discussed pretty openly among the industry that is difficult to meet when you have a motor carrier that literally by definition is in the business of transportation and a driver who is an owner operator and is in the business of transportation or moving things with his or her truck. So I think that it becomes very difficult to meet that B prong. There are ways to do it, in ways that folks are working on actively, but it is certainly much more difficult. And we would say, especially from a legal perspective, that any motor carrier hiring an owner operator is probably at risk of failing that test if they're hiring them as an independent contractor and not taking additional steps to ensure that the independent contractor status of that owner operator is preserved.
Sure. Are there any exceptions or exemptions to the ABC test that trucking companies may be able to use to get around application of AB5?
Yes, and I'm glad you asked it specific to whether there are exceptions that trucking companies may be able to use, because if you go and you actually read the law, it's a rule and then pages and pages and pages of exceptions. So there are tons and tons of exceptions, but specifically for the trucking industry, the one that applies that is most common is called the business to business exception. And it says that a business hiring another business wouldn't necessarily be found to have misclassified the independent contractor that is the business, as long as that business is free from control and a litany of other factors of the independent contractor. So if you think about it, it makes a lot of sense that there's this exception, because an employee cannot be misclassified if they're not a natural person. So if you have two businesses, a business can never be inherently in and of itself an employee. An employee is a natural person that has certain rights under the labor code, has rights as an employee, subject to meal and rest breaks. Well, meal and rest breaks wouldn't apply to a non-natural entity. But what you see a lot, and you see this especially with owner operators, and in the state of California, is you see individuals who are sole proprietors. So they could be employees if they're a person, if they're considered a natural person, but they start their own company, or they have a DBA, which is very, very common in Florida, meaning instead of using my personal name, I'm going to use another business name. But really what you're doing is you're still hiring that person. But if you're hiring an actual separate entity, and the person who's created the entity, the owner operator who's created the entity, treats it as an actual separate business, and that separate business is contracting with the motor carrier, then you can fall into an exception to the ABC test. It's not an exception saying you're totally off the hook, but it's an exception saying, okay, it looks like what we really have here are two contracting business entities, and that's totally allowed. That's totally fine. You can't misclassify that. And so then what the state will do is it will go down the path of looking at, it's California, so it's a 10-factor test to decide whether the business to business exception applies and that owner operator is truly independent. But there are definitely ways to do it, and I think a lot of folks are paying close attention to structuring their entities and their contractual relationship in a way that would legitimately fall under the exception.
Is AB5 and the way it's operating or anticipated to operate in California unique to that state, or is this something that may be coming up in other jurisdictions?
That's a really good question. Certainly the ABC test is not unique to California. Backing it up a little bit, misclassification is an issue for number one, every state has some form of parameters around what defines an independent contractor versus what would define an employee who is subject to the state's employment governance. And every state is going to have a certain level of that. Many states apply different tests that are a little bit more lenient, that focus on whether let's use the motor carrier owner operator example. They focus on whether the motor carrier is exercising too much control over the owner operator, so that the owner operator is really not independent. But the test that they look at is not as stringent as that ABC test, with that really tough B prong saying you have to be in a totally separate business. And I think that's really what's causing a lot of trouble in California. There are a few states that do have similarly stringent tests, although I think California has risen in notoriety to its ABC test as being one of the most difficult ones. Certainly, New Jersey has a very similar test that is considered similar in difficulty as California. And there was a recent decision out of one of the district courts in New Jersey that basically brought to light why it is quite difficult to properly classify an owner operator as an independent contractor in New Jersey. Illinois is another one that's considered a somewhat difficult state. And there are other states as well that follow suit. You can look at, I didn't bring one with me, but you can look at like heat maps to see which states have the more stringent requirements and which states have the less stringent requirements or are more independent contractor friendly. Florida, my state, is more independent contractor friendly. But then what's interesting is that's just only on the state level. You're talking about state unemployment law, state workers' compensation law, state meal and rest breaks, things like that. But there are also federal laws at play that consider whether someone is an independent contractor, including the Department of Labor and IRS standards. So every governing entity in the federal government, it also will apply different tests. Typically, the test seen at the federal level is a test called the economic realities test that looks again at whether the hiring entity or the motor carrier is exercising too much control over the independent operator. There have been indications that the Department of Labor may be considering a more stringent test, but we do not have that as of yet. So right now, California is probably the most stringent in the group, probably closely followed by New Jersey, if not at equal footing with New Jersey.
Has California done anything yet to implement this, at least as it relates to the transportation or logistics industries?
Well, it's current law, and the labor commissioner has said that they are looking at enforcing it. They have been issuing some advisories relating to trucking, but we have not seen actual enforcement taking place. That doesn't mean it's not taking place behind the scenes. The way that AB 5 plays out from an enforcement perspective is that it may be enforced by the state. So it can be enforced, again, with meal and rest break complaints or things like that. It can also be enforced by private individuals through PAGA cases, private attorney general actions in the state of California. Those are not the same across the board with all states. So not all states have these private attorney general actions, but California does. And basically what it means is that a plaintiff's lawyer can find an independent contractor who believes that he or she has been misclassified and actually bring an action on behalf of the state, saying that the law has been violated. And then if they are able to succeed in their claim, they not only recover monies compensating for damages for the plaintiff, but the plaintiff's attorney gets a hefty check. So there's a lot of incentive for plaintiff's attorneys to be bringing that. In addition, there's just private rights of action that are available to plaintiffs. Class actions are a risk here, the whole 9 yards. So it can be brought kind of all across the spectrum in California.
Is there something beyond withholdings that, I mean, in terms of calculation of exposure and damages that are potential for suits? What are we looking at here?
There can be civil fines for violating as well. And the extent of the civil fine is often based upon the extent of the perceived or found violation. So if you had an independent contractor fleet of 500 drivers that were owner operators and they were all considered to be misclassified over an extensive period of time, that could lead to very extensive damages.
And when I know that it's only recently that the Supreme Court's denied to hear the preemption issue, but is it possible that those kinds of damages calculations could go back in time to when AB 5 was first passed?
Well, I think the short answer is no. I think it would be unfair. And I do know that there was an injunction that was granted on enforcement of AB 5 during a period of time. It doesn't mean it wasn't the law, but I think, it depends on again, which angle of enforcement you're talking about. If you're talking about a private action by an individual that says, I have been misclassified for the past 10 years. Now, there might be statutes of limitation at play, but it's not like for a 2-year period while there was an injunction on AB 5 that that person could not be considered misclassified. They could still bring a damages action, and we see that all the time. These cases continued while AB 5 was held in abeyance, because it's not like the law didn't exist. The law has always existed in California. It's just that implementation of this particular statute and it's what I would consider relatively extreme standard that was held in abeyance during the injunctive period while the case was on appeal with the Supreme Court. But the claims can still proceed forward. Now, that's for private claims. I would say you're not going to get a labor commissioner action enforcing AB 5 from 2 years ago. I don't think that would be the case. I think the enforcement activity will start as of when AB 5 went into effect, which was in June. But private actions can certainly take place, and they are taking place. I've seen quite a few of them.
So what is a carrier to do, especially if they're operating in California?
That's the question. I spend a lot of my time working on that, as do, the handful of private transportation practitioners that there are in the United States, especially dealing with California. Number one, I think you have to do an audit to see, do you have independent contractors? And if you do, what do their contracts look like? What is the level of control that you're exercising over them? And go through the ABC test as if you're stringently looking at it through the eyes of a court or an enforcement agency to see if you have a problem on your hands. My guess is if you have independent contractors, if you're a motor carrier and you have independent contractor drivers in California, that you will have some level of a problem on your hands. So you will need to do that audit, consider the amount of exposure, whether you have tolerance for the risk that is created through that, and whether there's anything you want to do about it. Some motor carriers are set up to handle it quite nicely. I know some motor carriers have dual authority, or they have a related entity that's a broker, and they will simply tender loads to the independent contractors who are running under their own motor carrier authority. That is a really good way to at least meet the business to business or the B2B exemption. Does it mean that you're going to be off scot-free? No. Again, California is going to look at a test to determine whether you're exerting too much control. But I think that your chances are a lot stronger of having a successful independent contractor relationship there, because a broker, by definition, is in the business of arranging transportation. And a motor carrier, assuming that the owner-operator is running under their own authority, they are in the business of transportation. And I think that there's a distinction to be drawn there. Will the enforcing agencies need to be educated on this? Probably. Judges certainly will need to be educated on it. That's what I do. Anytime I'm in court on any of these issues, I spend the first, 75% of my case simply laying the foundation to teach the judge, or if it's a jury, what this business is all about and why one thing is distinct from another. But I do think that there are ways for motor carriers to set up properly and to still have independent contractors. Some motor carriers are simply switching to an employee model. It's certainly the simplest. It's not the end of the world. It doesn't mean you're going to lose all your drivers if you can't have independent contractors. It just means you might have to look at a different model. Of course, there's going to be a cost factor to that. I've heard a variety of estimates as to what the cost might be in switching over to employee model. I'm not going to toss those numbers out there, but I do have some insight into that if anyone wants to talk to me about it. And, those cost factors are then calculated back into pricing. And of course, that raises a question of competitiveness. And is someone who has an employee model that's more costly, assuming it's more costly, Are they going to be outbid in the market by someone who's relying only on independent contractors? And at what point is the tide going to turn on that? Because the person who has, or the entity that has all the independent contractors, they have an enormous amount of risk in California. And, I've seen countless lawsuits where there are settlements in the 7 figures over these things. So it's not a little risk, and that can really, that can really eat away at your cost savings if you've chosen to stick with the independent contractor model instead of an employee model, and you haven't put in the safeguards to make sure your independent contractor model is going to work. So I think motor carriers have some options. There are a few more too. I mean, some motor carriers have simply pulled out of California, or they've made sure that they're hiring, when they have independent contractor relationships, that they are hiring independent contractors who reside in other states. There's an open question on that as to whether the state of California, particularly with its enforcement actions, would have any jurisdiction over independent contractors who are residing outside of the state. And that you get into a little bit of an issue of competing state rights there as to which states' laws are going to govern whether a particular individual is an employee. Typically speaking, it's the state of residence of the person who is claiming to be misclassified, but I'm certain that there are exceptions to that, and I think that is being debated in the industry as well. But I do think your risk is a lot lower if you're hiring folks who are originating outside of the state. So that's something else that motor carriers are doing. There are a few other extremely complex models that I'm more than happy to talk about, but might put your listeners to sleep.
Sure. Well,
but they exist.
What you've been saying has made me think that there's, it sounds like there's quite a lot of uncertainty for carriers and also difficulties with the traditional business models that many have been using for quite a long time. But it also sounds some of that may sort of ripple effect out and affect brokers and shippers who have transportation and loads to move in and out of California. So I don't know if you're starting to hear about that or seeing that and concern coming through from some of your clients, particularly those that are based in California.
Yeah, oh, definitely. I think everyone's concerned. I think AB5 made such a splash. I mean, I was listening to national news the other day, and it was just the morning news, and they're talking about the supply chain crisis and AB5 and the trucking industry. And I think it was in regard to some of the protests in Oakland over the dray workers. But I thought, oh my gosh, AB5 is making national news right now. Everyone is concerned about it in the supply chain industry. It's not just the motor carriers. So, and I think for good reason. It obviously, if the costs go up by the motor carriers, that's going to have an impact on the industry. I think there's a concern of litigation risk that brokers and shippers alike have if a motor carrier is sued for misclassification. Who is going to be swept up into that lawsuit? And certainly we have seen lawsuits that sweep in brokers and sweep in shippers as joint employers. That is not uncommon. Interesting factoid is that if you're brought in as a defendant on one of these cases and you are not the actual hiring entity, meaning you're not the motor carrier that has the contract, the actual line of contract with the independent contractor, the ABC test doesn't apply to you, but you can be brought into the claim on theories of joint employment in California. So there's still a risk to you as a broker or as a shipper to be brought into these cases on theories of joint employment. Obviously, shippers and brokers have a lot more control because they can define the relationship that they have with the motor carrier. They're not going to get, the motor carriers aren't suing brokers and shippers for misclassification. That's not happening. I mean, maybe I'll qualify that by saying it could happen if you had an owner operator single unit person who had motor carrier authority and then was hired by a broker through a contractual relationship. I could see a misclassification claim there, but generally speaking, large motor carriers are not bringing lawsuits against large brokers for misclassification. The brokers and the shippers get swept in if there's a class action among a group of independent contractors or a single independent contractor is suing for having been misclassified, and they sue under a joint employer theory. Shippers can protect themselves with good contracts. I see them do that all the time. Lots of indemnity provisions and competing indemnity provisions in those contracts. The same with brokers. I also see brokers and shippers, asking motor carriers if they're in compliance with AB5 and whether they have independent contractors that they're using, and making sure that they are in compliance. So there are things that those up the chain can do to protect their interests and avoid being brought into these lawsuits. But it is certainly increasing the risk with them as well, and increasing costs.
Yeah. So it sounds like a lot of uncertainty and potentially, ripple effects that involve maybe cost increases and capacity.
Yeah. And I really want to point out that there are a lot of disgruntled independent contractors over this. I mean, you saw protests. Those protests were people who wanted to continue to be independent contractors, and they felt like they were being forced out of it by the change in the law. And I think the industry, particularly the trucking industry, has been really reliant and has developed a system to use independent contractors. There's even concerns about if you're not an independent contractor and you can't, especially with owner operators, you can't go out and get your truck and then lease it back to the company through a lease arrangement, that you really lack some of that fundamental independence that certain drivers really like to have, and the feeling of pride and ownership that comes in owning your company, that goes away if suddenly you're being forced to be an employee. I'm not saying it's what everyone wants, but I am saying that there is a segment of the industry that takes pride in and wants to continue to support the independent contractor model, and they are frustrated by AB5 because they feel they can no longer do that in their home state of California if that's where they're from. So there is some frustration there. There is one other group that I often get questions about that I wanted to offer up some clarity.
Yeah, please.
Which are independent contractors outside of the state of California. I have received numerous calls from clients who say, hey, I have an independent contractor in Idaho or wherever, and they're concerned because they occasionally run loads into California and they don't want to be breaking the law. I would just like to clarify, if you have any independent contractors who are listening to your show, that independent contractors are not breaking the law by being independent contractors. The law doesn't prohibit their existence or their relationship, and it especially doesn't prohibit an independent contractor relationship outside the state of California, nor is AB5 triggered simply because someone runs a load into California. I think, if you're doing it every day and if you're frequently working in California, there is that kind of gray area I raised before. But simply being an independent contractor in another state and running a load into California does not put you in violation of the law. And being an independent contractor in California does not put you in violation of the law. The law does not make it illegal to be an independent contractor in California, which I've seen pretty frequent misconceptions about that.
Well, thank you for coming on and telling us what we need to know and what we need to be thinking about, at least as AB5 sort of transitions into potentially an enforcement phase in the near future.
Yeah, I think it is. I think it's pretty much in that phase now. I know that the California Trucking Association is still considering whether it has any other options to push back against it. I'm certain that there will be some lobbying in the future in attempts to maybe refine the law or add exceptions, but I think it's definitely in an enforcement phase now.
And you've given us definitely if anyone has questions, I think you've shown that you'd be a good person to call or those at your firm. So thank you again.
Thank you. I'm always happy to take calls. And I also, I have really great relationships with the private practitioners in transportation across the board in the United States, and we have a very lovely network of practitioners. And I think I truly love practicing in this area of law. And so if I can't help you, I will always find someone that will be able to do that.
Well, great. Thanks again.
Thank you, Adam. This was fun.
Yeah. Have a good rest of your day.
Thank you.